What you know, Alibuyers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Saturday, December 6th. We are going to go over the newest filing in the Kouri Richins case. I have several more from the last few weeks, and I'm hoping to get through those this weekend before trial starts back on Monday for Brian Walsh. I updated a very short video yesterday, just going over what happened at the hearing yesterday. The video for that has not dropped yet. I had a friend of mine in the courtroom who was kind enough to give me a rough outline of everything that was talked about. But if that video drops, I'll look through it and see if there's anything of substance there to do an additional episode. I also have several other documents that we have not gone through. They're from the last few weeks when I was taking time off. So I'm hoping today and tomorrow to start knocking those out in some additional episodes. But for today, we are going to read the state's reply in support of its motion to determine admissibility of the walk the dog letter. But first, I thought it would be a good idea to reread that walk the dog letter because we forget these things and it's always good to have a refresher. And this was found in her cell during a search. So let's jump in. At the top, it says in big letters, walk the dog. To the side of that, but take vague notes so you remember. And just a reminder, Skye, that she refers to in this letter, is her former attorney. Skye is saying, even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them, though. However, she wants to link Eric to getting drugs and pills from Mexico, so we need some kind of connection. Her private investigator is doing some research on the ranch/cartel place Eric would stay at. Here's what I'm thinking, but you have to talk to Ronnie. Ronnie is her brother. He would probably have to testify to this, but it's super short, not a lot to it. You will need to tell Skye at the meeting next week. And she starts with what she wants her brother to testify to. Upon information and belief, and she puts in parentheses, just like they say. A year prior to Eric's death, Ronnie was over watching football one Sunday, and Eric and Ronnie were talking about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers at the ranch. Not to tell me, because I would get mad, because I always said he just gets high every night, and he won't help take care of the kids. There are pictures in my phone of Eric passed out on the floor or in the chair. Ronnie should have texts from Eric talking about getting high as well. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck so I wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen could get him some. Carmen being the housekeeper that ultimately got Kouri the fentanyl. Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Kouri to go down for him. When they traveled, Eric would put his drugs in Kouri's bag at the airlines right before they boarded. That way, if they were caught, Kouri got in trouble, not him. Once they got to wherever they were going, Eric would pull the drugs out of her bag and it would cause a huge fight. She was pissed he would risk her going to jail for his drug use. He just would laugh about it. Eric couldn't ruin his image that he had drug issues, so he would do whatever he had to. Kouri has never done any type of pills. Didn't like them. Rarely, she would consume THC only if Eric begged her because it was a special occasion. There's a little star here and it says, reword this however he needs to make the point. Just include it all. The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. He can be short and to the point, but has to be done. Upon information and belief, LOL. They never found pain pills or fentanyl in my house because he hid it in an allergy bottle in his work truck. And Cody emptied out the work truck within a week. Cody was his business partner, so they were never found. When you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phone are bugged. Maybe drive down to Salt Lake and meet him after work without Bree. Skye has to make the connection between Eric and Mexico because that makes the most sense in her mind. If it's Ronnie's information and belief about the conversation over football, she can use that as a connection. Tell Ronnie, don't overanalyze it. It was a quick 2-minute conversation, LOL. Tell him I need him to do this. Bring me home and then we will get those damn bitches. Also, please text Lotto or call. Tell him, do not text me anything about us doing things together ever, like church, skiing trips, nothing that puts us together. It doesn't look good. We're so close to the end. Let's push through. Have the conversation with Ronnie before he meets with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there. We're almost there. Love you to the moon. At the bottom, it says, take vague notes of all of this so you remember before you walk the dog. I saw a commercial yesterday, Utah Mortgage Relief. Google them, please. It's for people behind on their mortgage. Can you see if they can help at all on Marissa's house, please? We have to get hers, yours, and Chelsea's taken care of ASAP. Try to go to that place in Camas. What about asking Lotto to do a loan solely in his name and not have you on there? I know he can do a home equity line of credit on his house in Hideout. Not sure if he would, but I know he has like $1 million in equity. Maybe he just doesn't know about a HELOC, which is a home equity line of credit. If he wants to help me, taking care of these loans is most important. I don't give a crap about the Yotels. Remember, I told you one way to get at Katie is to go through my phone and find a picture of her girls, even with the boys. By the way, Katie is Eric's sister. Print 15 copies and send them out anonymously to different media companies. Obviously, don't email the pictures so it's not traceable. She would be livid if it got out to the public. You would just have to do it sneaky and be careful. She would try and trace it back to you. If not, no worries. Guys having my girls do the first interview with Good Morning America. Please tell Chelsea to bring up that he hasn't been to church in the 13 years she has known him. And Eric would brag to her about how much he drank and did pills in high school. Tell Kelsey to say Eric always wanted Kouri to go down for him. For example, he would put drugs in her suitcase when we would travel together. So if anyone got caught, it was Kouri. He would put it in her bag right before they left the house so Kouri didn't know. Then, when we would land wherever, Eric would take them out of her bag and Kouri would be pissed and they would argue about it. Have Kelsey to say how Eric didn't care and would just laugh about it and say, well, I can't get in trouble, as if it was okay that I got in trouble. Have Selma talk about Eric in Spain not being able to drink, so he was looking for drugs the entire time, and explain the drink the waitress gave him and how I called his doctor and went to the pharmacy immediately. Have Allie talk about how the sisters have always been jealous of me because anything they could do, Kouri could do better. Being a mom, college, stay-at-home wife until she built $1 million company, a nice house, car, everything. Everything she had, they wanted. This comes down to jealousy, money, and Eric's partying that they don't want to acknowledge, and sadly, an accidental overdose. Lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it to use in our defense. Will you buy a box of Crest white strips, open them up, put them in an envelope, and have Sky give them to me? You can tell her what's in the envelope. I'm sure she won't care. I'll make sure they can't be found in my cell. My teeth are yellow from so much coffee and tea all day, and she puts a little sad face there. I love you, I love you, I love you. Hang in there. We're getting there, slowly. You're the best mom in the whole world. I'm so lucky to have you. So that was the walk the dog letter, and that is the subject of a lot of filings because obviously the defense doesn't want that in. So let's read the state's reply in support of its motion to determine admissibility of the walk the dog letter. The first section, statement of new matter. The defendant's response to state's motion to determine the admissibility of the walk the dog letter overreaches legally and factually. As set forth in the motion, the first 3 pages of the walk the dog letter are admissible because the defendant's consciousness of guilt is relevant, more probative than unfairly prejudicial, and proves her intent, plan, and identity in causing Eric Richins' death. Part 2, argument rebutting new matter. The defendant's Rule 402 argument is legally unsupported and factually accurate. So what is 402? It's about admitting evidence like letters, texts, emails, motive or intent, consciousness of guilt, contradictions to a witness testimony. And what about when a judge may not allow 402 evidence to come in? It could be because the facts are not tied to any issue in the case, which clearly isn't the case here. Character evidence unrelated to permitted purpose, and anything that doesn't make a fact more or less probable. The next section, the argument rebutting new matter. The defendant's Rule 402 argument is legally unsupported and factually inaccurate. The defendant asserts that the walk the dog letter is not relevant because statements made in a vacuum cannot possibly be relevant. The defendant does not cite authority for this assertion because it's not true. Indeed, the defendant's consciousness of guilt is revealed in her writing the walk the dog letter, not in anyone reading it. The walk the dog letter speaks for itself as statements do all the time, and the consciousness of guilt it reveals tends to make it more likely that the defendant caused Eric Richins' death. Accordingly, and set forth in the motion, the walk the dog letter is relevant. Moreover, contrary to the response, the walk the dog letter was not eternally locked in a vacuum. Rather, there is a strong inference that defendant intended to convey it to another individual. First, it's written to her mother. The day before authorities recovered the walk the dog letter from the defendant's jail cell, she rehearsed sending letter number 2 to her mother using HomeWave's video feature to bypass the jail's normal mail screening. A HomeWave video is essentially a FaceTime on the tablets they have there in jail. Regardless, it simply does not matter that authorities seized the letter before the defendant sent it to her mother. In State v. Braun, the defendant wrote a letter during his murder trial that was intercepted by jail staff and subsequently introduced against him at trial. The defense objected to relevancy and argued that the quoted parts of the letter are vague and subject to more than one interpretation. The state offered the letter as relevant to establish an inference of defendant's consciousness of guilt. In ruling on relevancy, the trial court found that the letter reasonably could be construed as an attempt to engage a fellow inmate to take action against a trial witness in order to stop him from testifying further. The Oregon Supreme Court found the state's interpretation of the letter to be reasonable, if not compelled. It held that the letter was relevant to establish an inference of defendant's consciousness of guilt for murder, and the defense was free to argue at trial that the letter had in fact had another meaning. See also State v. Colthurst, admission of an instruction about a written escape plan entitled Brainstorm found during a routine search of the defendant's belongings at a correctional facility was relevant to consciousness of guilt. They cite another case, State v. Pelletier. A written prayer found on defendant's person at the time of her arrest generally acknowledged my sins and my guilt was relevant to consciousness of guilt. The next section, defendant's Rule 404 argument is logically erroneous and factually contradicted. The defendant cites 3 cases where courts admitted evidence of threats of physical harm to show an attempt to influence a witness and thus consciousness of guilt. She then argues that the court should not admit the walk the dog letter because it does not include a threat of physical harm and thus cannot give rise to a consciousness of guilt. Clearly, a jury could find the walk the dog letter shows an attempt to influence a witness and thus consciousness of guilt, even though it does not contain a threat of physical harm. The defendant asserts that the walk the dog letter is not consciousness of guilt evidence because the statements in this letter can just as easily be interpreted as a reminder as to what the defendant's brother can truthfully testify about. This interpretation, however, is highly unlikely given the defendant's lengthy and repeated explanation that the walk the dog letter is a sloppy, rough draft of a, quote, freaking book, wholly unconnected to Eric Richins' death. Accordingly, as set forth in the motion, the walk the dog letter is admissible because the consciousness of guilt that it reveals proves the defendant's intent, plan, and identity in causing Eric Richins' death. The next section, the defendant's Rule 403 argument is legally imprecise and logically erroneous. Under Utah Rule of Evidence 403, a district court may exclude otherwise relevant admissible evidence if its probative value is substantially outweighed by a danger of unfair prejudice. They cite State v. Blackwing. At the outset, the court must indulge a presumption in favor of admissibility. They also cite State v. Johnson. The probative value of evidence is judged by the strength of the evidence and its ability to make the existence of a consequential fact either more or less probable and the proponent's need for the evidence. In applying Rule 403's balancing test, phrases like substantially outweighed, unfair prejudice, and roused the jury to overmastering hostility matter. The defendant does not argue from these legal standards, but instead cuts single words from these phrases and reassembles them to fabricate a more obliging standard. Put artfully, as set forth in the motion, the defendant's own words revealing her consciousness of guilt are highly probative because they bear directly on her agency in causing Eric Richins' death and are not the subject of alternative proof. And any prejudice arising from her own words is not unfair because they are her own words, and not the type of words that would rouse the jury to overmastering hostility. And even if unfair, the danger of any unfair prejudice does not substantially outweigh the probative value of her own words revealing her consciousness of guilt. Moreover, contrary to the response, presenting the walk the dog letter to the jury will not confuse and mislead jurors into thinking that they are deciding a witness tampering case instead of an aggravated murder case. Jurors are smarter than that. Accordingly, as set forth in the motion, the walk the dog letter passes Rule 403's balancing test. For the conclusion, the court should determine that the first 3 pages of the walk the dog letter as redacted, consistent with the court's privileged determination, is admissible for trial as a statement of a party opponent. That was dated December 5th. So that was the filing. Like I said, I have several more to go through, so I'm hoping to knock those out this weekend. And just a reminder, her trial is coming right up in February. And one thing I did put on the update from the hearing yesterday is not to expect much publicly as far as filings. The defense is filing a lot of things under seal, and Judge Mrazek is okay with that due to the fact that we are so close to trial. So we'll see what happens. But that is it for this episode. I hope you guys have a good rest of your afternoon, and we will see you soon.